Ripple and the U.S. Securities and Exchange Commission are not done yet, but they're trying to wrap things up. Both sides have just refiled a motion asking for what's called an indicative ruling. Basically, permission from the court to change a decision that was already made. And this isn't just a small change. They're asking to drop the injunction against Ripple's XRP sales and to release the $125 million that's been frozen in escrow. Let's break this down. This story began with a ruling in August 2024 when Judge Analisa Torres handed Ripple a mixed decision. The court said Ripple had violated securities laws only when it sold XRP to institutional investors. Retail XRP sales were not considered securities. Because of that, Ripple was ordered to pay $125 million and stop all institutional XRP sales going forward. But in May 2025, Ripple and the SEC tried to update that ruling. They had reached a settlement. $50 million would go to the SEC, the rest would be returned to Ripple, and the injunction would be removed. They filed a motion for an indicative ruling to formalize that deal. However, Judge Torres denied it. Why? Because according to her, the two parties didn't show exceptional circumstances, which are legally required if you want to change a final judgment. That's Rule 62.1 of U.S. Civil Procedure, something you can't ignore, even in a settlement. Now, both Ripple and the SEC are trying again. They've refiled their motion, but this time under Rule 66. That rule allows a final judgment to be modified for any reason that justifies relief. It's a broader approach, and they're hoping it works. So what are their reasons? First, they say the settlement agreement itself is enough reason to modify the judgment. If the court doesn't approve the changes, then the whole agreement falls apart. Both Ripple and the SEC argue that modifying the ruling is the only way to give full legal effect to the deal they've already made. Second, the motion highlights something very important, a shift in SEC crypto policy. Under new leadership, the SEC has softened its approach. For example, it has recently dropped lawsuits against other crypto firms like Coinbase and Consensus. So, Ripple and the SEC are saying, if those cases can be dropped, why not this one? They want to bring the XRP case in line with this new direction. Third, both sides argue that continuing the appeal would waste judicial resources, especially in the Second Circuit Court of Appeals. Instead of dragging the case further, they're offering a clean and mutual exit. That's the legal side of things. But how is the XRP community reacting? People like Ashley Prosper, a well-known XRP advocate, believe Judge Torres might issue a decision on this new motion soon. Another voice, Bill Morgan, a legal commentator who follows crypto law closely, said he expects the judge to approve it this time. If she does, here's what happens next. The case will be sent back from the appellate court to Judge Torres. Then she'll enter a new, modified judgment that reflects the updated settlement, and that would officially end this multi-year legal battle. Now, let's think about this from a broader perspective. This motion shows us something bigger. The SEC is starting to act less like an aggressive regulator and more like a negotiator when it comes to crypto, dropping lawsuits, settling quietly, and allowing companies like Ripple to move forward. This signals a possible policy pivot. And Ripple? They're trying to close the chapter, pay the price, and move on with their XRP business. If the court agrees, Ripple walks away with a cleaner legal record, and XRP might gain even more legitimacy in the eyes of the market. But let's not forget, this is still a legal process. Until Judge Torres signs off on the new plan, nothing is final. So, in the end, this is more than just a settlement. It's a test of how the U.S. legal system handles change. Can old judgments be adapted to match new realities? Ripple and the SEC are saying yes. Now it's up to Judge Torres to decide.